What we want to talk about today is it's twofold. It's the exclusive buyer agency agreement, and it's also your buyer's consultation and your buyer's presentation, so that you're working with the buyer and building that trust before you even go into the explanation of the exclusive buyer agency agreement. And I liked it on one of the recent all hands. They didn't call it an exclusive buyer's agency agreement. They called it a loyalty agreement. And that's exactly what you're doing in your buyer's consultation with these people that you're going to begin to work with. You want to build that loyalty and go through the entire dialogue with them. So what happens in your, do any of you now sit down and meet with your buyers? What do you go over with the buyers? And what do you say to them upon first meeting with them? What do you do? Anybody?
I haven't really been working on with buyers as much. I've been doing more listings, but I do plan on using the agreement when I get qualified buyers. I guess I signed up for some Zillow ads again. Um, but yeah, I think it's gonna be it for me. I've gotten into situations where I was working with buyers and then they went with like a relative as a realtor. So like that agreement I think is important just for me to use because if you're wasting like 2, 3 months with them and then they go with another realtor. So I think the loyalty agreement is going to help my business in particular, just because of the previous experience I've had with it,
Right.
with not
Laura,
using it, I should say.
you use buyer's agency agreements in Pennsylvania exclusive when you were exclusively working in Pennsylvania, weren't you?
Yes, we do. We have them sign immediately. It's like just like a consumer notice. Well, you guys call it consumer information statement here. But yeah, we have them sign immediately. It's not like I'm going to take any of my clients, and this is before to to court. But at least it sets up the standard or the expectation for working with them. And it also, there's a lot of I've encountered other really loyal realtors that have said, hey, have you signed? Because they start hopping when they're on Zillow, they just hit that button or realtor.com. And now other realtors are saying, hey, have you signed a contract with somebody? And it's forcing that conversation, it's forcing that conversation because people say, oh yeah, I did. And then that realtor has always been like, all right, well, you need to contact Laura if you want to see this property.
100%. So what happens is, and when you get to that point, before you even start to explain what's in the exclusive buyer agency agreement, is the question to them could be, one of your talking points is, have you ever sold property? And wait for their answer. If their answer is yes, then you immediately can correlate when they listed their property for sale with the agent that ultimately represented them in the sale of their property. And they had a listing agreement with that agent to sell their property. Well, that's the equivalent of what the exclusive buyer agency agreement is. It is an agreement, it's a contract between the buyer and you as the agent, and ultimately us as the office, because you're going to say that you are, you could be a buyer's agent or dual agent if the opportunity arises. And this is my agreement to help you buy your house. So if they've never sold any property, then you've got to explain the workings of how it works. But in your buyer consultation phase, in the documents that are in command, we have the required documents on consultation of your CIS, the wire fraud, and the disclosed dual agency. The exclusive buyer agency agreement for the time being is still conditionally required. But in the market that we're in and the posts and the continue to be in the lawsuits that we're in, you want to build that loyalty. You want to have this in there and you explain to them when you go through the document. The first thing is where do you want to look? Well, where you want to look, that comes from your buyer consultation phase. When you are doing the needs assessment with these buyers, you're sitting down with them for the first time. You want to find out, where are you looking? What towns are you looking at? We don't want you to use and put in this document a specific town. We strongly recommend that you do it by county. And for most of the agents that are in the Parkview's office, those counties are gonna overlap. Cause you could have a buyer that's looking in Bergen County, Lower Bergen County, Rutherford, Lyndhurst, North Arlington, and the next thing you know, you're over in Nutley. Well, it's a 5-minute drive, but you cross county lines, and now you're looking in a town that's in Essex County. So we want you to put in there, instead of municipalities, Bergen County, Essex County. You could put Passaic County in there. You could put Morris County, where you think they're going to look, because that will then define it. It's not a specific town anymore. You have to ask the buyers on consultation if they have an agreement with another agent. Now, a buyer could have more than one exclusive buyer agency agreement. For example, maybe they were working with a buyer in Northern Bergen County, and they have an agreement for a specific town or Bergen County. And now they've come to you because you were working and you're gonna show them properties in Essex County. So a buyer, unlike with listing a house for sale, with the exclusive buyer agency agreements, the buyer can have two. And they're area specific. So they're gonna work with John Smith in Bergen County, and they're gonna work with you in Essex County and Passaic County. So it's okay, but you need to find out first if they've signed anything. And ultimately, you wanna see the copy of what they signed, because just like with listing paperwork, if you have a buyer agency agreement with a buyer, they should have a copy of the fully executed buyer's agency agreement. You're gonna talk about how you represent them, that with the dual agency, that there's the potential for dual agency. The term of your agreement. It could be 2 months, it could be 3 months, it could be 6 months, it could be a year. You might have buyers that are not gonna want to sign an exclusive buyer agency agreement for 6 months. That's okay. Sign it for 3 months, work with them, show them the properties, build the loyalty, and just like with a listing agreement, when it's about to expire, you would need to just either extend it by having them initial the extension dates, or do another agreement for another 3 months. It's okay. It's better. I would rather see you get them signed, even for 3 months, than to not get them signed at all. Because in that 3 months, I know the super agents that we have in this office, you're gonna build that rapport with them, that they are going to wanna continue to work with you. Now it comes to the fee. That's the next paragraph that's in the exclusive buyer's agency agreement. You need to have a fee in there, but you have to have the talking points with the buyer so that they understand how real estate works. And for the most part, Mr. Buyer, for most of the listings, this seller would indicate the percentage that the seller is going to pay, the seller's agent is going to pay the cooperating buyer agent and buyer agent office. And that's gonna be in the listing. There could come a time where it's a very low commission, say it's a listing where they're only gonna pay out 1.5% or 1%. Or 0%, as we've seen in pockets in Newark where there's a bunch of listings up with 0%. So you explain to your buyer that in that event, it would be the difference of, so if you have 2% on your exclusive buyer agent agreement, and the listing agent and that office is going to cooperate to a point of 1.5%, you could have the buyer, through the buyer agency agreement, come up with that other 0.5%. Or if there's a situation where there's no compensation to the buyer's agent, it would be the entire 2% of the purchase price. So how do you work that? You can have the ability to negotiate if there's 0% being offered. You can try to negotiate with the seller that the seller is going to pay your commission, or you would increase the purchase price on the contract for the commission, and it would be a seller's contribution at time of closing for that percent that your buyer, under the buyer's agency agreement, would be looking to pay the office. The only time you cannot get paid from two different parties, the seller and the buyer, is if this office represents both the seller and the buyer. Right now, under law, we can't do that under the real estate commission. The buyer's agency agreement goes on to explain your duties, what your duty is to your client, where you're gonna look and how you're going to keep them updated. And there's duties there for the buyer to notify you when they see something. When they see a sign, don't go to the open house without telling me so that I can register you. Don't just call the office and make an appointment to see the property. You, in essence, you and this buyer are married. You're married for a period of time until either they purchase a house and it goes to closing, or they decide for whatever reason you can't work with them anymore. But you are in an agreement to work together for a certain period of time. Any questions so far? No questions? Okay. So how do you build loyalty on a buyer's consultation? What are some of the things, Yanni, you're on now. What are some of the things that you do to, when you sit down with that buyer for that first session? What are some of the things you do to build the loyalty?
You asking me, Joyce?
Yes, ma'am.
So loyalty is mainly, I mean, it's building to let them know that you're representing them, like you're representing them and have them to be having the trust to work with you. So I will have them sign the paperwork that I will be representing them as either a buyer agent or even listing side or that. And then it also asks a lot of questions about them, and then they communicate and find out about them, and they will communicate and find out what are their problems or what are their needs, and building relationship with them.
Exactly, and that's where that is why the buyer's consultation is so important. Because before you're even getting into that agreement, you're sitting down with them and you're almost doing a needs assessment on these buyers. Asking them all sorts of questions as far as, obviously, if you collect the important stuff, which is their name, their email, and their phone numbers, but what's their urgency? When do they want to be in this home? Are they, is it a short window of time? Or are they just new to the process and looking to work down the road? You need to know areas, and what are their wants? What are their must-haves in a home? What are their, this is great, but it's not a deal breaker type of thing. And once you build all of that, it will then, number one, it helps you understand where the buyer's looking for. It also makes these buyers feel that you're taking time. You're asking a question, but then you're listening. And then you probe another way. So if they talk about their urgency, then your clarifying question to them then would be, so you want to close and be in this home before school starts in September, or you want to close and be in this home before whatever. And now you've done two things. You're clarifying their position, but you're also showing these buyers that you're listening, and that all helps to build up the rapport. You want to know what they want in the interior. Are there more than just the two of them? Will the parents be possibly, or one parent or whatever, moving in? And is there a certain floor setup that they want? So you're going through all of this, and KW has a great buyer's brochure that you can customize in or from your command area, that you can go through this with them and make it all about them and have them understand that you're trying to understand what they want. Now, if you've got first-time home buyers, I used to love working with first-time home buyers. They had no clue in the process, and they were like a sponge that absorbed everything. Well, the National Association of Realtors has a document that shows 105 different things that you have to do or could do with a buyer. From the first consultation and building a relationship and that first session, straight through to educating them, preparing them, what was gonna happen in the contract phase, in the negotiating phase, in the home inspection phase, and all of this. This again, when you show to your buyers all the different ways that you have to interact on their behalf, that also goes to build the loyalty. So when you've had this meeting with them, you've found out their wants and needs, you've explained to them the buying process. Now the final piece is the loyalty agreement. By then you've built up the rapport. If they haven't talked with mortgage yet, that's the time to bring Mike Santana into it from Carnegie Mortgage. That's the time to get Mike involved. And so that they know. Sometimes first-time home buyers have no clue how much house they can afford. God bless you. They don't know, because they're in an apartment and they've got car loans and they're going out to eat and they're going out all this entertainment. Well, what do you have to put down on the house? And what is your monthly payment gonna be that you're comfortable with? And to back end then into how much home they can afford. Because the last thing you wanna do is work with buyers that have unrealistic expectations about the house that they can afford. So you want to get them qualified so that you're looking in that price range that they are going to feel comfortable in making an offer, especially with the situation where we're still having multiple offers on properties. That hasn't changed. So all the more reason to have them qualified, and Carnegie can get them to a point where they've gone through the steps to a point that they're basically a cash buyer when you're out looking at properties, and that helps you when you're making an offer on the property. But you take all of these steps, and by the time you're done with this, you have built the loyalty that they are going to sign the agreement. Now, some agents will tell you that they'll show one house. Just because they want to see this house, it's a new listing, okay, we'll see one house. But then you still then after that have to have that sit down with them, because technically that CIS needs to be signed at the first meaningful contact. Well, if you're showing them property, that's meaningful contact. So your CIS should be signed at that point. And then you could then go on to the needs assessment. Sometimes it just, they want that house and then they'll sit down with you. But you really need to try to set that time and go through it, and don't rush the appointment, so that you can go through all of the steps in the buying process and then hone in on the exclusive buyer agency agreement. And I don't care if you call it a loyalty agreement, you most certainly can. I love that name, but unfortunately, the NOR and the New Jersey Association of Realtors calls it an exclusive buyer agency agreement. And then once you have that signed, your CIS, your informed consent to dual agency, and your wire fraud, and those 4 documents, then you would upload into Command, because by now you should have an active opportunity for them. And those 4 documents would be in the consultation phase of your opportunity. Any other questions on that so far? You guys are quiet. Okay. Let's explain one more thing that's not quite an exclusive buyer agency. It's the importance of the AFBA that is part of the under contract phase with your buyers. According to our code of ethics and the real estate commission, we have to disclose an affiliation that the office has with our affinity partners, Carnegie Title, Carnegie Mortgage, Carnegie Home and Auto. It's a disclosure. And again, in light of all of the lawsuits around there, the more disclosure you have, the more it will work. You basically explain to them that I'm disclosing to you that our office has a relationship with these 3 entities. And that's why we need you to sign the disclosure statement that I have told you about that. You aren't required to use them. We hope you'll use them, but it's not required, but I have to disclose my relationship and my office's relationship with these 3 parties. Attorneys require clients to sign that if they have a specific company that they're using and they're going to be used on their buy side. This is nothing new, but we've been a little lax in getting these signed. The one specific with the AFBA is that it has to have the address of the property that you're going under contract on, or that you're putting the offer in on. So each time if you've got buyers that are putting in offer after offer after offer and not getting them accepted, every time you do a new contract for the buyers, you have to do a new AFBA. And it needs to be signed at the time the buyer is signing the contract. And then as soon as that contract is fully executed, you need to put it into command and upload the AFBA. And then we can take it from there. But we've seen in my checking for compliance, sometimes the AFBA doesn't have an address. They got it signed once and then there's no address. And it has to have the address of to match the contract. It also needs to be signed, if there's two names on the contract, it needs to be signed by the two people on the contract, not just one. And that's just, we have to clean that paperwork up as it relates to the buyers a little. Any questions on the AFBA? Right? How many of you were here and heard my spiel on the flood, on the new flood zones? Everybody out in Zoom land?
I heard it.
Who, are you the only one there, Laura?
I hope not.
Who else is there?
No, I'm here.
Okay.
here.
All right, so just to be clear, and just, I'm not gonna dwell on it. This law takes effect on March 20th. It is, and the documentation that the sellers have to do with the flood certification is going to be incorporated into the seller's disclosure. The seller's disclosure is going to have to be filled out on every listing that's taken. What we're still waiting to find out is if you've got listings that are due to close after March 20th, if that section has to be filled out prior to the closing. Working with buyers, the buyers need to see that seller's disclosure and sign it before they make an offer. It's not a document that the listing agent can send to you after the offer's been accepted. Because there's clear questions in there, and according to the law that went into place in June, the buyers must be given this form prior to making the offer on the property.
Is that if the seller fills it out though? Like if the seller doesn't fill it out, we just have to have the seller sign a statement at the top stating they're leaving it blank intentionally, correct?
No longer, because when this law was enacted in June and passed in June, part of the law said that the vehicle for disclosing and handling these questions and all for the flood certification. And one of the questions is not just about a flood zone. And I'll give you an example of that. In my town in Hasbrook Heights, last year when there was that big heavy tropical storm that came in and dumped 4 or 5 inches of rain in a very short amount of time, it flooded our main street, which is called the Boulevard. Well, the way the Boulevard works, the side streets go downhill from the Boulevard. So the Boulevard was flooded and all this water rushed down these streets. There was so much water and such a force that it took 3 houses off their foundation on the block over from where I live in Hasbrook Heights. So it isn't just the documentation and the questions that are going to be in the seller's disclosure now are not just for flood zone specific properties. Because one of the questions says, was your property ever damaged from heavy rainfall. So yes, no longer, after March 20th, no longer can the seller, you can no longer put that statement at the top of the seller's disclosure, seller declined to fill out. Because now there's a New Jersey law that says the seller has to answer those questions. So we still need
What
to
if the
get
seller
that.
has no knowledge? Like some people I've come across, they don't have any knowledge of like a lot of the stuff with the house. They bought it, or they might
There are
inherit.
yes and no, there are yes and no questions, but it has to be done. What we're getting determination from attorneys on is, can the seller not answer the question, the rest of the form, and just these 8 or 9 questions that relate to the Flood Notification Act. But right now your sellers are gonna have to sign it. The buyers are gonna need to see this before they make an offer. In addition, there's a questionnaire that your landlords are going to have to complete. That's gonna have to be given to prospective tenants as it relates to flooding by the apartment that they are going to rent. And the leases are gonna be updated with a paragraph that informs the tenant that they can, in addition to their tenant's insurance, they can obtain flood insurance for their contents of their apartment. Any more questions on floods? I mean, just look at what happened in New Jersey 2 weeks ago. They got a rainstorm 1 week, they hadn't cleared it out, and they got another rainstorm. And some of these areas were not flood zones, they're just low-lying areas that can't handle a large amount of rain in a short amount of time. And that's what this new law that the governor enacted in June is to help. It's to help disclose it. Any other questions?
When dealing with an estate sale, like what if the executor of the estate really has no knowledge?
If you can do some research, if you're specifically in that regard, if you're working on a listing and the executors don't know, the first thing you would do is go in and look at the flood maps through the MLS. You also can have the estate can order through Carnegie Title a flood cert. So that if they don't know, I would recommend that I think Justin told me, Ryan told me it was $10. I think it's something that if they're not sure, that they should have. Just for disclosure purposes. The seller's disclosure form will still have a section there for an executor to sign. That they have no knowledge of the condition of that house. And that's at the very end of the seller's disclosure. So 100% if you're dealing with an estate. So I'm glad that Ariana brought up estates. Just for point of clarification, if you are working with a potential seller, and at the current point in time, the person living in the house that the house is in their name of had a power of attorney. But in the process, the person passed away. That power of attorney doesn't exist. power of attorney ceases at the time of death. And at which point, the will would need to be processed, and we would have to have a copy of what's called the letter testamentary, which defines who is handling this property for the estate. It's very important when you know it's an estate that you might be dealing with one individual. And there could be more than one sibling in that family. You need to see that document and you need to find out who's signing it, who is the executor or the executrix, depending man or woman, for that estate. We've had a situation in this office where an agent was dealing with one of the children. Listing paperwork was signed, it was put into the MLS, and the next day the agent gets a letter from an attorney. Because there was another sibling that was also an executor of the estate, but they didn't want the house sold. If you have more than one executor, both executors have to sign the listing paperwork. The same as if the house is in a husband and wife's name, the husband and wife have, or whoever the house is in the name of, have to sign the listing agreement. If there's more than one executor handling that estate, both executors have to sign the listing agreement. But when you put that listing agreement in and the owner's name and you have estate of Mary Smith, DocuSign automatically comes down onto the seller side, and if you're not careful and you don't pay attention, the automatic signature down on the bottom says estate of Mary Smith. It can't say that. Janine's gonna kick it back for compliance. It has to say Joe Jones, executor. So you have to pay attention. So if you need to know, and the only way you're gonna know how many executors are in that estate is if you see and take up an image of the letter testamentary, which establishes who has the authority to dispose of that property. That document needs to go into command as well. Any questions on estates? I know we've kind of traveled off, but there are all sorts of questions that we see them come in and then we have to kick them back because the paperwork is not signed properly.
Joyce, I'm sorry, I don't want to just interrupt it. Can you what is that document that we need to see and
It's-
take a photo? What's it
Okay,
called?
so when a will is probated,
Mm-hmm.
and the executor, or I'll just say executor for now, but obviously executor is a male, executrix is a female.
Yes.
When the will has gone through probate, there is a document that is issued with the seal of the county seat that says this person has been appointed the executor of the estate of John Doe.
Okay.
And that then says that that person has the legal authority to handle all the affairs of the estate. But you just need to be careful and make sure there's only one. Because if there's two, both executors or an executor and an executrix, both of those people that are named in that document that comes from the county after the will is probated, both of those people have to sign the listing paperwork.
Now, what if there's siblings and only one person's name is on that document? Does the other sibling have no right at that point or no rights at that point?
Well, I mean, if whoever left made a decision to leave one sibling in charge, what they do battle over the other, then it would be up to that other sibling, if they really had, felt, shunned, would be to take that, to challenge that document in court, that, they were, not legally entitled to anything. We see it more where there's more than one, and then one wants to sell and the other doesn't. That's where I've seen the issues. For the most part, families get along.
Okay.
But, when they start arguing over who's getting the house in the Hamptons and who's getting the house in the, it could get ugly. But, you need to deal with the person that's been appointed by the court to handle the, affairs of the estate. Anybody else? We should have the Keller Williams exclusive buyer agency agreement in the next week or so. But that doesn't mean there is an exclusive buyer agency agreement in your opportunities for your buyers in the consultation phase. And that until we switch it out and put the new one in, there's nothing wrong with the one we have. There are fill in the blanks, and you have to make sure that you put all of the information in the blanks as far as the locations, and explain to the buyers how it works with commission. We're not seeing too much of zero commission being paid out. The most I've seen is, it was a listing in Maywood, and the seller was offering, the selling office was offering cooperation of 1.5%. And then in the comments, the agent comments, it said, buyer's agent is free to negotiate more. But we haven't truly seen, we thought we were going to see an immediate turn to 0%, but we haven't seen it. But that doesn't mean that you can't. Disclosure that's gonna be the hotbed word for 2024. You need to explain dual agency, explain who works for who. Explain that the agency is created and it has nothing to do with you. It has everything to do with the office. If there's two agents in an office and one agent represents the seller and the other agent represents the buyer, you are working with, if you're working with the buyer, you're working with the seller, you're still working for that person. But Keller Williams Parkviews represents both of them. And that's what creates dual agency. And when you explain it to them that way, they understand. But the more you explain and disclose, like with the AFBA, the better off it is, because then everybody knows how everybody's working in the transactions. Any other questions, guys? I don't hear any. So you're all going to work on your value propositions to sit down with your buyers and explain to them why they should work with you, how you're going to work with them, what services you're going to provide for them. And then that will lead right into the loyalty conversation, and you're going to get your document signed. We did, just as a point of reference, we had an agent lose just about $50,000 in commission because a client decided to go work with somebody else after he had conversations with an agent in our office. This is what you need to do to build the loyalty and protect it. Okay, hearing no other questions. You're all rock stars on the buyer agency department now, right?
Of course.
That's right. If any of you want the 105 ways that, that you work, there's actually 2 documents from National Association of Realtors. 105 ways that, agents work with their buyers. And there's 179 ways that the realtor works with a seller. So if you want either one of them, let me know and we can email them out to you so that you have them. What I'll do is I'll have them uploaded into, have Amanda upload them into the document section so that you can find them there.
Thank you.
Okay? All right,
Sounds
guys,
great.
have a great day.
Thanks, Joyce. You too.
Good luck in all
Thank
of your
you.
work, and you know where I am if you need me.
Thanks,
Thank
Joyce.
you.
All right,
Have a good
bye-bye.
one.
Bye.
Bye.
You want one? Yes.